Hi, I'm Linda Chung, co-chair of the Beverly Hills Bar Association's Trust and Estate section. Welcome to today's program, Estate Planning with the Copyright. This is a hugely popular topic, obviously. We have more than 200 people signed up for this program. I have announcements. Please mark your calendar. On October 7th at 12:30, we have a one-on-one program regarding understanding the unique challenges of probate confirmed real estate sales, presented by our own sponsor, Nancy Sabban, and Brenda Depew from Hinojosa and Fora. On October 20th, we have our annual probate attorneys lunch without the lunch. The Trust and Estate section and all of its webinars are sponsored by our generous sponsors, the Sabban team, Geffen Real Estate, Glen Oaks Escrow, and California Title Company. Nancy Sabban from the Sabban team and Ori Gadish from Geffen Real Estate are here with us today to say a few words. Nancy?
Okay, hi everyone. It's kind of great to see you, not see you, but have our meetings back on. I just wanted to thank everyone for their continuous support these past so many years and let you know, if you are willing, we are going to continue our monthly drawing where we will make a donation to the children's charity or pandemic charity of your choice. If you click on this chat button, you will find the link. Anyway, have a good year and everyone stay healthy.
Go ahead, Orit.
Hi, everyone. My name is Orit Gadish. My firm, Geffen Real Estate, provides full-service custom solutions to my probate and trust clients. We uphold a deep commitment to work with you to determine the best solution to fit your needs and the needs of your clients, whether it's selling a property in as-is condition or completing a full renovation to realize the maximum return on the sale of a property. I have the years of experience to provide the proper oversight and management. If there are no funds available in the trust or estate, my team of vendors can do it all and get paid through escrow, and that includes a professional organizer, trash out, complete renovation, and landscaping. Count on me to provide you with the expert guidance and the highest level of concierge service to you and your clients. Again, I'm Orit Gadish, broker and owner of Geffen Real Estate.
Thank you, Nancy and Orit. We have a couple of other sponsors. Glen Oaks Escrow. Marcin Klein is a full-service escrow officer specializing in probate, trust sales, conservatorship, and both the court and independent administration of estate act transactions. On a daily basis, Marcin works to ensure that even the most challenging escrows close smoothly and that her clients are happy, beyond happy with their experience at Glen Oaks Escrow. Last, California Title Company provides comprehensive and timely title insurance protection for home buyers, including first-time home buyers, sellers, veterans, military personnel, seniors, real estate agents and brokers, mortgage lenders, and commercial real estate professionals. Now I'm going to turn the meeting over to Andrew Smith, who will do the update.
Good afternoon, everyone. I have one legal update today. In the case Buskirk v. Buskirk, it was the Second District Court of Appeal, filed August 14th, 2020. The case site is 53 Cal App 5th, 523. In this case, trustors, husband and wife, executed a trust in Los Angeles County and chose California law as the governing law in the trust. The husband died in 2005 and wife became the sole trustee and the sole current beneficiary. The trust was administered in California from 2005 to 2016 with some help from the wife's brother who lived in Nevada. But in 2016, the wife was moved to Idaho under, let's just say, controversial circumstances to live near her daughters. From there, the wife cut her son, who still lived in California, out of the trust. Additionally, the trust had consisted of several real properties in California, but when the wife moved to Idaho, she transferred the trust properties so that most of the assets consisted of real properties and bank accounts that were located in Idaho. The wife also brought a series of lawsuits against her son in Los Angeles County after she had already moved to Idaho. The wife's son filed a suit against the wife in Los Angeles County, arguing that the wife's various transactions violated the trust interests, and he sought an accounting of the trust and the wife's removal as trustee, as well as the removal of the wife's daughters and the wife's brother as successor trustees. The wife and her daughters moved to quash the son's petition for lack of personal jurisdiction in California, and they also sought dismissal for lack of standing and for mandatory venue in Idaho. No party brought a forum nonconvenience motion. The trial court ruled in favor of the wife, finding that the son failed to establish minimum contacts with California because the wife had lived in Idaho, the majority of trust assets were now in Idaho, and the son was no longer a beneficiary. The trial court also found that it thus lacked personal jurisdiction over the wife, her daughters, and her brother. The son appealed this ruling, and the Court of Appeal reversed the trial court. It found that California did have personal jurisdiction over each of the respondents. First, the Court of Appeal found that the wife had, quote, intentionally connected with California for their own benefit by first accepting the trusteeship and the trust benefits connected with California, which had been established in California and still held interest in California real estate. Second, bringing several lawsuits against the son in California. Third, engaging in transactions in California aimed at extinguishing the trust interest in the California real estate. The court also found that the wife's daughters and brother had sufficient contacts with California by being beneficiaries and successor trustees of the California Trust and participating in trust transactions in California. The court found that, quote, a defendant need not physically enter California at all to be subject to personal jurisdiction here, nor could the wife, quote, undo her lifelong California contacts by moving to a new state. Second, the court found that the son's claims related to the respondents' contacts with California, since the respondents were, quote, connected to California through the trust, which is the topic of the son's suit. Third, the court found that exercising jurisdiction over the respondents in California was fair, and that the respondents failed to meet their high burden to show that exercising jurisdiction over them would be unreasonable. In this finding, the court noted again that the wife had brought previous claims against the son in California, for which the wife's daughters traveled to California to prosecute on the wife's behalf. And now I would like to turn it over to Joe Goldman, who will introduce our speakers.
Thanks, Andrew. We're very lucky today to have two incredible attorneys who have a particular expertise in this complicated area of planning with copyrights. The first is Paul Gordon Hoffman, who's a founding member of the law firm Hoffman, Sabban, and Watenmaker. Paul's been named a super lawyer, a top 100 lawyer, and even the top tax lawyer in the Los Angeles metropolitan area. And he's even willing to put aside rivalries by serving on the planning committee for both the UCLA Estate Planning Institute and the USC Trust and Estate Conference. Steve Krone is of counsel at the law firm of Mitchell, Silberberg, and Knupp. He specializes in many facets of entertainment law, including representing media companies, investors, artists, and executives. And that's whether those clients work in the movie, TV, or music industry, or even with online content. So basically, if you have an entertainment issue of any kind, Steve's your guy. So without further ado, I'll turn it over to Paul and Steve.
Okay. So we're going to start with Steve, who's going to be introducing the topic of copyrights, what they are, how they work, and then I'm going to be talking about some of the estate planning issues that you have when you find an estate with copyrights in it. So Steve, you're up.
So the topics I'll be covering are the first four. Copyright, yes, in a sentence. We'll talk about duration of copyrights, which is somewhat complicated depending on when a work was created and first published. We'll then talk about some unique aspects of copyright involving music. And then finally, termination of transfers. There's a provision in the copyright law that I'm sure most of you are familiar with, if not all of you, that enables the author or subsequent beneficiaries to terminate transfers of copyright or licenses of copyright. And that's obviously very important from estate planning. Paul will go over the trust planning and estate planning topics when we get to him. So moving on to copyright in a sentence, I won't read all of this, but you'll find in general my slides are designed so that you really don't need to take any notes of any kind, hopefully, or very little. But don't worry, I'm not going to read every word on the slides. I'll try and move through it pretty quickly. So just for those who maybe never took copyright in law school, which by the way includes me, I never took copyright in law school. So what is a copyright? It's the exclusive legal right of an author, and as we'll see, that's not always the creator, with respect to certain original works of authorship that are fixed in some tangible means. And you see a list there of the kinds of works that are covered by the copyright, to do all sorts of things with regard to that work, including to reproduce the work, distribute copies of the work, prepare derivative works, a movie based on a book, a play based on a song, a book based on a painting, whatever. And with regard to certain types of works, to publicly perform them or display them, to record or transmit a live performance, and with regard to fine art, the right to receive attribution and maintain artistic integrity by not having the work altered. And that takes us to duration. With regard to duration, there are three buckets, so to speak, of works. The first are what are generally referred to by copyright lawyers as post-1978 works. That means works that were created on or after January 1st, 1978, without regard to whether they were published or not at that time. So what is the term of copyright for those post-78 works? Generally, the term is the author's death plus an additional 70 years. If there's more than one author, if it's a joint work, and we'll talk a little bit more about joint works later, it's the death of the last author. However, there's a certain group of works where the duration isn't based on the author's death. So-called works made for hire, we'll define those in a moment. Anonymous works, works that are, I think that's self-explanatory, or pseudonymous works. Again, these are all cases where either the author isn't identified or it's a work for hire. And in those cases, there's an alternate calculation. The earlier of the first publication of the work plus 95 years, or the creation of the work plus 120 years, whichever is a shorter period or would give rise to the earlier expiration of the copyright. As we'll see on the next slide, the durations that I just described apply to works originally created after January 1, on or after January 1 of 78, also generally to works that are only first published or registered for copyright after that date. Copyrights always expire on December 31st, so you don't need to look up the exact date of an author's death or the date of publication. They always expire on the last day of the relevant year. And of course, the duration can be changed by statute. It has been changed many times. These are the durations under the current law. So the next bucket of works are what are generally referred to as pre-78 works. These are works that were created before and are unpublished as of January 1st, 1978, and not in the public domain at that time, are already in the public domain. The terms are the same, so I won't repeat them. There's just two little wrinkles for so-called pre-78 works. The first one is, in no event does the copyright on works that meet this description, created before and unpublished as of January 1st, 1978, in no event can the copyright expire before 2002. And if the work is published before 2002, then there is no expiration prior to 2047. These obviously are going to feel like somewhat strange and arbitrary rules. What I haven't done here is give you a sort of archaeological explanation of all the various copyright acts and how we got to these numbers. I wanted to just focus on understanding what the durations were which is probably, most useful for all of you. Finally, we have works that are still governed under the 1909 Copyright Act. These are works that were both created and published before January 1st, 1978. With regard to these works, things are a little more complicated, not that they weren't already a little complicated. So under the original under the 1909 Act, copyright was for an initial term of 28 years plus a renewal term of 28 years. Under the 1978 Act, that 28-year renewal term was extended to be 47 years instead of 28. And in 1998, the renewal term was again extended to be 67 instead of 47. So as of the 1998 Act, the duration of copyright for these works, pre-78 works, if properly renewed, is an initial term of 28 years plus a renewal term of 67 years. But depending on when the work first got copyright protection, the rules are a little different. For works that were first obtained protection in 1923 or later and were renewed prior to 1978, they have the full 95-year protection, 28 plus 67. If they first came under copyright protection between 1950 and 63, renewal was required in order to get the 67-year extension. If renewal wasn't properly done, then you only have the initial 28 period. For works that first were protected as of 64, registration was no longer required for renewal. There are still reasons to register renewal, but even if you didn't, you still have the full 95-year term if the work was first subject to protection in 64 to 77. This only goes up to 77, obviously, because then you roll into the previous slides dealing with 78 and pre-78 works. All of this means that anything that was published before 1923, that is before January 1st, 1923, is now in the public domain and no longer subject to copyright protection. So that's a lot, but hopefully I've given you notes in the slides here to refer back to for reference. So the next topic I want to cover quickly is vesting and assignment of the renewal right. That renewal term doesn't vest at the time it was created by law. So it's considered a new estate that occurs at the end of the preceding copyright term. So who gets that? Well, if the author is still alive, it goes to the author, obviously. I've put in parentheses that it is terminable because the last subject I'm going to talk about is termination of copyright, and an assignment of this renewal by the author is terminable. There's also a further little wrinkle. If the author is dead, generally this right would vest in the surviving spouse and children. But there is an exception. If the author renews the copyright in the final year of the initial term, the 28th year, and assigns that renewal right to someone else, assigns the benefit of the renewal to someone else, that's a good assignment, even if the author dies before the initial 28-year term expires. But otherwise, if the author dies in the 27th year or does not renew as described, then the renewal passes to the surviving spouse and children. If there are none of those, then to the executor of the will, and so forth. You guys are all trust in the state's lawyers, so I don't think I need to read the rest of that. There are certain types of works, including works made for hire, where the author, the legal author of the work, or the owner of this right, isn't the creator. And in those cases, this doesn't apply. And again, we'll talk about exactly how to define a work for hire momentarily. So this renewal right is assignable. a beneficiary can assign it in advance and it may not vest. If it doesn't, if the expectancy fails, then the assignee takes nothing. The law has a strong presumption against conveyance of these rights. So it needs to be very clear. If it involves a spouse or children or someone that is taking the renewal right who isn't the author, they need to be a party to the grant. The law has a strong presumption against these rights being transferred. Work for hire. I kept promising you that I would talk about work for hire. So what is a work for hire? There's essentially two separate ways in which a work can be considered a work made for hire. The first is that it's prepared by an employee within the scope of his or her employment. So if you work for Microsoft and you write a technical manual, that is the property of Microsoft, your employer. In the entertainment industry, as many of you I'm sure know, often creators of copyrightable works are not considered employees. A writer who is hired by a studio, for instance, to write a screenplay. Very often, authors of books, they write the book pursuant to a publishing contract, or perhaps they sell it after they write it. In both of those cases, they're generally not an employee of the publisher. And that's where the second bucket comes in. So a work that is specially ordered or commissioned for use as part of a motion picture or other audiovisual work, and then the Copyright Act goes on to list 8 other categories of works. That's a work for hire if the parties expressly agree that it's a work for hire in assigned writing. So work for hire language is generally included in screenwriter contracts, director contracts, television producer contracts, et cetera, et cetera. Now that does not mean that those works are always works for hire. If a screenwriter sits down and writes a screenplay, not specially ordered or commissioned, and then sells it to a studio, that's an assignment of the copyright. It is not a work for hire, and that transfer would be subject to termination. If, however, the studio hires the writer, commissions them to write a certain screenplay for agreed upon salary, that would be a work for hire, assuming the writing says that it is, and then it would not be subject to termination. And essentially, the studio, in my example, would be considered the legal author for all purposes. So if it's a proper work for hire, the creator is not the author under copyright law, but rather the employer is. And now a little bit on joint authorship. We saw that some of the prior rules change a little if a work is a joint work. So let's just quickly define that. It's not enough that there's more than one person working on the work. It has to be the case that the authors are working with the intention that their contributions are merged into an inseparable whole. It's not merely a combining of separate elements. It is an intent to merge it into a single work. Teams of writers in the motion picture industry generally work as teams, but there are certainly many other contexts where that is not the intent. The author of a book has an editor. It may be hard to untangle the editor's contribution, but of course, with very limited exceptions, the editor is not, or rather the two parties don't enter into an agreement with the intention that the editor should be treated as an author, and therefore they are not an author. Legal treatment of joint works. In the absence of an agreement between the joint authors, each author has an indivisible half interest and can deal in the copyright without the authorization of the other party. For instance, entering into an agreement to license a book to be made into a movie. It actually does not require the permission of both joint authors. Obviously, that's best practice, but there are cases where only one author can bind, and in that case, they have an obligation to account to the other author. And as already mentioned, with regard to duration and joint works, it's measured from the death of the last surviving author. Now I'm going to talk a little bit about music. Music copyright is a little esoteric in terms of the types of rights. People tend to have a better intuitive sense of the copyright in a book or a movie or a television show or maybe even a painting, but music is quite strange. So the first thing to do is to distinguish between sound recordings and compositions. A sound recording is the thing you listen to, a record, a CD, a digital stream. It's the performance of the song, a physical recording of the song. Believe it or not, those have only been protected by copyright law since 1972. When we talk about compositions, we mean the underlying song, the notes and lyrics written on a page. That's the composition and is subject to a much broader array of copyright protection. There's a list there, I won't read them all, but those are the types of rights that are protected with regard to music, reproduce, distribute copies, etc. I'm not going to read the others because I'm going to touch on them in the following slide. So, generally these rights are referred to as music publishing rights. That is the copyright protection accorded to a musical composition. Those are generally referred to as publishing rights, and there are several kinds. The first is what we call a mechanical right. If someone wants to take your song and record it, put it on an album, do a cover of another version of it, sample it, etc., in addition to whatever rights they may need to the recording itself, which are called master rights, they need the right from the owner of the song to use it in any of these forms, and that's called a mechanical right. The idea being that the song's being put onto some mechanical device that then replays the song. In the United States, the Harry Fox Agency is responsible for negotiating these licenses and collecting the royalties. The CMRRA is the Canadian equivalent. So again, we'll pick up with music publishing rights. The first is the right to take the song and put it on a record, to turn a composition into a song, or to reuse any version of the song. Those all require mechanical rights from the owner of the composition, or the so-called publishing rights. Again, those are negotiated and collected by the Harry Fox Agency in the United States or its counterpart around the world. There are many, many that do this. As you can imagine, this involves lots and lots and lots of licenses. And furthermore, under US copyright law, it's a compulsory license, meaning once a composition has been recorded by anyone, an authorized recording, future folks do not need permission. There is a license, there's a statutory right that is paid. As a practical matter, that sets a ceiling. There's a negotiation to lower it. But once somewhere over the rainbow has been recorded, if I want to put a version of that on my album, I don't need to negotiate a license, but I will in order to obtain a lower rate than the compulsory license rate. Public performance rights. So anytime a composition is played or performed in a public space, that can be anything from the Hollywood Bowl to a barber shop or a restaurant over the radio. That's considered a public performance of the song. And PROs, performance rights organizations, you've probably heard of ASCAP, BMI, and maybe even CSAC. They're responsible for negotiating those licenses and collecting royalties, which are then distributed among all of their members based on formulas about the popularity of various songs. So the Hollywood Bowl would have one kind of license for which they would obviously pay quite a bit of money, and that would cover all of the artists that perform there, whatever songs they perform. That would cover the payments to the owners of the underlying publishing rights in the songs. If they play things over the speaker during the intermission, etc. A small restaurant would have a much smaller license. But the basic idea is that the PROs go out and negotiate all of these licenses on behalf of all of their members, collect all of those license fees, and then distribute them among their members. And obviously this continues to get collected for the entire term of copyright for these compositions. Synchronization rights refers to the right to use the composition or some performance of the composition in synchronization with visual images. So if you want to use a composition in a movie or a television show or a television commercial, sync rights have to be negotiated. These are often the most valuable rights, especially for songs that are not super famous, because using a song in a television show or a movie can offer, or a commercial can often garner a very high license fee. A couple others to mention: print rights. Sheet music is still a thing, although obviously it's mostly distributed digitally, although there are still obviously music books and sheet music. That is a copy of the song. So royalties have to be paid by sheet music companies. Grand rights refers to the right to use musical compositions in dramatico-musical works, such as a live musical or an opera. That's actually a distinct right from the synchronization right, and also has to be uniquely negotiated for. And just a final note regarding all of these rights: as I said at the outset, all of the rights I just described are rights that we refer to as publishing rights. Those are held by the author or the owner of the publishing rights in the underlying song. It has nothing to do with a particular recording of the song. That also requires a separate license called a master use license from whoever owns that master. It might be the artist. It's often a record label. So if you wanted to sample a song, you would have to get a master use license from the owner of the recording that you are sampling, and you would need to get a mechanical license from the owners or the authors of the underlying composition. Next slide. They are once again not moving on my screen, so just bear with me just a second. And that brings us to the final topic, termination rights. So essentially, termination rights are designed to give an author, a creator of a work, a sort of second bite at the apple to protect against the possibility that a license or an assignment that they did a long time ago was a bad deal. Even if a transfer says this is forever, it's for all the terms of copyright, if the requirements are met, the termination rights apply. So I'll go through how a termination right works, and hopefully by the end of that, it'll be fairly clear. So what copyrightable works does this apply to? It applies only to, or I should say, rather than which works, which transfers does it apply to? It applies to transfers made on or after January 1st, 1978. They must be inter vivos transfers, so this would not apply to transfer by will, by the author. And it has to be an author who is a creator. So if it's a work for hire, the creator does not have a termination right. Again, if you're employed or you're specially commissioned under the requirements that I described earlier with regard to a work made for hire, you as the creator of that work do not have a termination right. Conversely, if you write a book or write a screenplay or create another kind of copyrightable work, and then you transfer it to someone and it's not a work for hire, the termination rights apply if that transfer was inter vivos and on or after January 1st of 78. When does the termination right become effective? We're actually going to talk about its effective date before we talk about how you actually cause the termination to happen. So the termination happens in a 5-year window as of 35 to 40 years after the execution of the grant. Termination can only happen in that 5-year window, by which I mean it can only take effect, if at all, in that 5-year window. As you can see, if it's a publication right that you're terminating, there's a little tweak to how you measure that 5-year window. So how do you actually affect the termination so that it occurs in that 5-year window? You have to give a notice to the transferee or assignee, and the notice must be given at least 2 years prior to the desired effective date of the termination, but no more than 10 years. So, for instance, if one wanted to terminate 35 years after a grant, they could give notice as early as 25 years after the grant, or as late as 33 years after the grant. And they would, assuming it was done properly, and I'll get into that, termination would occur 35 years after the grant. But that also means in order to effectuate the latest possible termination, 40 years after the initial transfer, notice must be given no later than 38 years after the transfer. Because notice has to be given at least 2 years early, a failure to give notice by the end of the 38th year would mean you no longer have the ability to terminate. So you terminate in that 5-year window by giving a notice 2 to 10 years prior to the date on which you are giving notice that the termination will take effect. So who controls the termination right? Who owns this right? If living, the author owns the right. And again, if it's a work for hire, the creator is not the author and does not have this right. Nobody does. So we're talking about an author who is the creator. If the author isn't living, it passes to the surviving spouse, the surviving children, and surviving grandchildren of any dead children. This mechanic, I assume, is one that you guys are familiar with in other contexts, although I'm not really sure if that's right or not, frankly. So you see the description there, the spouse 100% if there are no surviving children or grandchildren. Otherwise, the spouse has 50%, and the surviving children and grandchildren divide the other 50% per stirpes. When there's a group of surviving grandchildren of one child, they need a majority to act on behalf of that piece of the ownership. If there's more than one owner of this termination right, it requires a majority to act. So in situations where it's 50-50, you need agreement. In situations where, say, you have multiple surviving children and a spouse, obviously there are other combinations that would enable you to act. I mentioned that there has to be a notice. The notice, in addition to being sent to the party whose rights are being terminated, it also must be recorded in the Copyright Office before the effective date of the termination. Finally, very important provision. Termination can be done, NWS is notwithstanding any agreement to the contrary, including an agreement to make a will or to make a future grant. So any language in any agreement that says, I promise not to exercise the termination right, or encumbers the ability of the owner of the termination right to use that right, is not enforceable under the Copyright Act. Now, there are scenarios where licensees will ask for matching rights or certain sorts of negotiation rights, and I'm not going to dive into that topic now. I think Paul may touch on it. We may revisit it in the questions, but that can get quite complicated whether or not certain sorts of provisions constitute agreements notwithstanding and are therefore not enforceable. Certainly, an agreement not to exercise a termination right would be unenforceable. So, what happens when a termination occurs? The rights revert to the owners of the termination right. Even in a situation where minority owners elected not to be signatories of that notice, it could be done without them knowing, or they could simply not want to participate, they still get their corresponding share of the rights that have reverted in the same proportions as all of the relevant parties own the termination right, as reviewed on the previous slide. Now, there are some limitations. When a termination occurs, it is not the case that all rights under copyright come back to the owners of the termination right. So the first exception is very important. This only applies to rights under US copyright law. So a termination does not terminate rights that are protected under international law. Let's give a concrete example. If an author wrote a screenplay on spec, they were not hired to write it as a work for hire, and then they licensed or transferred the right to make movies and television shows, etc., based on that screenplay to a studio, and they terminated, what would come back to the owners of the termination right would be the rights that were transferred with regard to exploitation in the United States. So now a further movie could be made based on that script in the United States. The screenplay could be published as a book in the United States. But the studio, in my example, would retain the rights to exploit outside the US. Secondly, any derivative works that are prepared prior to the termination can be exploited pursuant to whatever the original agreement was, which often is in perpetuity, not always. So again, going back to my example, if 2 movies were made based on that screenplay that I described, notwithstanding a termination, the owner of those 2 films would be able to continue to exploit them, including in the US, according to the term of that agreement. What they wouldn't be able to do is to create a 3rd movie after the termination, or a new TV show, or other new works. Finally, there are some limits on what the owners of the termination right can do once they have the rights back, and that's the last thing I'll cover, and then I'll turn it over to Paul. So these are restrictions or limitations on further grants or agreements to make them by the parties who own the termination rights. So the termination rights come back to the owners. In order to dispose of them, they need the signature of more than 50% of the people who own the termination right, just as they did to exercise the termination right in the first place. That, just like the termination itself, will bind the minority owners who did not sign. Finally, an agreement to dispose of these rights, the regained rights, the terminated rights, is generally only valid if the agreement is entered into after the effective date of the termination. So even though someone can give notice 2 to 10 years prior to the effective date of the termination, they cannot, during the period in which they have given notice, but the termination has not yet become effective, they cannot enter an agreement to dispose of those rights with a third party. They have to wait until the rights have actually terminated and come back to them before they can enter into such an agreement. But there is an exception to that limitation. If the further grant is with the original grantee, that is the very same party on whom they served the termination notice, there's an exception for a negotiation period with that party. So effectively what the Copyright Act is doing is it's giving the original grantee a sort of exclusive negotiation period, or at least the possibility of an exclusive negotiation period, because there's a period during which that's the only party with whom a deal could be reached. There's no obligation to negotiate with that party, but it is the only party you could do a deal with prior to the actual effective date of the termination. And with that, I will turn it over to Paul.
Okay, well, we don't have much time left, so I will do what I can. I suspect we're going to need a whole nother session to try to deal with this properly. I really want to make is there's an exception, as Steve mentioned, on the termination of transfers, on a transfer of the copyright by will. And that's literally what it says. And so I think most people believe that a transfer to a revocable living trust, in fact, starts a termination period running. So we always exclude copyrights from our general grants so that we don't accidentally start an early termination period by the transfer into the revocable trust. All right, so one question is, are copyrights community property, or does the Copyright Act effectuate a federal preemption? And the bottom line is a case decided in California, the Worth case, and a case decided by the Fifth Circuit in Louisiana made it clear, at least in those jurisdictions, that copyright is community property. However, what can happen is termination rights can supersede community property rights. So for example, if a couple gets divorced and then the author remarries and dies, the author's new spouse may be able to effectuate the termination rights and get all of the rights back, notwithstanding the rights of the first spouse. Valuation is really important. How do you value a copyright? And basically what you're trying to do is estimate the value today, the present value of a future stream of payments. And so what you generally would do is look at what has come in the past few years and take a look. Is the trend downward? Is the trend steady? Is the trend going upward? Is there some unique event that occurred during that period of time that will not recur in the future? And you have to come up with a value. Part of since it's a present value discount, what's the appropriate discount rate to use? Also, will there be changes in the marketplace? You know, we've already seen the elimination really of album and CD sales and the substitution of streaming. Will there be real books read anymore, or is it all going to be electronic? Will there be changes in the marketplace? All of these are going to go into the determination of value. Clearly, you're going to need to get a qualified appraiser. Generally, there are some really good CPA firms in town that do this sort of work. And they can come up with a value for you. But again, it's only for the period of time that you can control it. So for example, if you terminate the rights early and recoup them, you may have a much longer period of protection. If you die and haven't terminated the transfers, those rights are vested in the spouse and kids. And so the value for estate tax purposes is only for the remaining term until those rights can be terminated. And those rights belong to the spouse and the kids. They are not passing from the author, and therefore they do not enter into the valuation for federal estate tax purposes. When an author dies, at least under current law, who knows what's going to happen in the future, at least we get a stepped up basis at death. Now that assumes that you own the copyright. If you've licensed the rights, you still own it. But if you have sold the rights, then you only have a right which is income in respect of a decedent. You don't get a stepped up basis as a result. So you need to think about that. In general, copyrights in the hands of the author will not be a capital asset. There's a special rule since 2005 that treats music copyrights as capital assets. This is under section 1221A3. But if you're talking about other rights, like the author of a book, if it's the sale of a copyright by the author whose personal efforts created it, you've got ordinary income when you go to sell it. But when the author dies, now it's no longer a sale by the taxpayer whose personal efforts created the work, and therefore the kids or the spouse can sell it and have capital gain treatment. If you've got an asset that's got a basis, for example, as a result of a step up at death, you can amortize that, you can depreciate it, you can write off that basis over time. And you're going to write it off over the remaining useful life of the copyright. So again, you're going to not only look at how long the copyright is there, but also how long it is before, say, renewal rights would, or termination rights rather, would kick in. In general, though, you are going to depreciate or amortize it on a straight line basis for the remaining life. Okay, one of the things you should think about doing when you've got copyrights is who should hold control of those rights subject to the termination rights. Sometimes people will name a literary executor. Sometimes people will create a literary trust to hold the copyrights and to allow the rights to therefore be exploited by somebody who knows what they're doing, do the licenses and so forth. So you should think about creating a literary trust and naming a literary trustee to hold those rights. Generally what I provide is that only enough money can be retained in there to operate the literary trust. All other monies must be distributed to the regular trusts that you're creating under your estate plan. Also, be sure to plan for incapacity. Make sure that you've got an attorney in fact who knows what they're doing to manage the rights if the author becomes incapacitated. If you've got a trust and monies are coming in, will the copyright royalties be treated as income or principal? As a general proposition, the California Probate Code provides that 90% of the money that comes in from the copyright is principal and only 10% is income. It's been our sense that that does not meet with the expectations of most authors or songwriters or whatever. They think of all of the money that comes in as the income. And so generally we will draft our principal and income clause to say that, but it's worth talking to the client and seeing what the client expects. I see that our friend Les Klinger is one of the participants in today's program. And Les was the editor of the new annotated Sherlock Holmes, and he brought a lawsuit against the Conan Doyle estate, trying to deal with the question of the character of Sherlock Holmes, because Sherlock Holmes was created in fact over a number of books, a number of stories over time, and changed over time. The character elements changed over time, and I would commend to you looking at what's happened there to see what exactly happens when you've created a character over a number of books, and the character is what you want to use. I also want to talk about something that's related to copyright but not directly, and that's what's called separated rights. If you have an author of a screenplay and it's under the Writers Guild Basic Agreement, the copyright may well vest in the studio, but that doesn't mean that the author is without any rights at all. Under the Basic Agreement, in general, if you have a story by credit or a created by credit, and you're a Writers Guild member, you're going to have certain rights, such as the right to do the stage play, or certain novelization rights and certain sequel rights. And so when you've got a big hit film, then even though the author may have done it as a work for hire and may not be the author, under the Writers Guild Agreement, they've got other rights that are significant. We are just about out of time. There were a few questions. Somebody asked me to repeat what I mentioned about transferring copyrights to a revocable trust. The issue is that if the author transfers the rights to the copyright to the revocable trust, that starts a termination period running. And I've had the situation where authors don't want their statutory heirs to have any rights. For example, the author has one child from whom he is completely estranged, and he wants the copyrights to benefit a charity. If he leaves the work to his trust by will, then you don't set up a termination period. But if you transfer it by an assignment to the trust, then when the termination period ends, that child who has the sole right of termination, assuming the author is dead, would be able to get those rights away from the charity. So again, don't have copyrights in your general assignment. Make sure to exclude them from your general assignment. You may have to go through a probate to get them in. They're transferred through the Register of Copyrights. But still, I think it's better to think about doing that and making sure that you get the benefits flowing to the people you care about. Now, sometimes you can get some real problems, as we were talking about earlier. When you have a spouse and kids, you need more than 50% in order to effectually terminate a termination right. So if you have, say, a child from a prior marriage, and then you have a child from the current marriage, the spouse and the child from the current marriage will have more than 50% and will be able to effectuate the termination. If you have, say, two kids from a prior marriage and the spouse, surviving spouse, and no kids from this marriage, then you got a deadlock and you got to work something out. We're really out of time, so I want to thank everybody for their time and attention. And as you can see, this is a topic that has a lot of nuances, and perhaps we can go through something, another session at another time.